Hey everybody, Harry here to talk about the final stages before trial in the Fox versus Dominion defamation lawsuit. Start with a little law, just a little law. Here's basically how a civil case works. Somebody files a complaint, and then the other side will say, oh, dismiss this. You don't even have to get evidence. It's totally garbage. No matter what, they could never state a claim. Sometimes they win that. If they lose that, it then goes to discovery, which is a whole slog and the bane of many young lawyers' existence, where you take depositions and give documents over, etc. Once all those facts have been put together as they have here, and we know many of the facts because they've come out in the papers. That's the things we've been reading about that Fox people said in depositions. So that's been in discovery. Now there's one final stage before trial. It's summary judgment, when each side says, here are the facts, and you don't even have to take it to a jury. In fact, you may not take it to a jury because we have a legal right. No reasonable jury could hold otherwise than from us. Now, you might scratch your head a little and say, how could both sides say in a lawsuit, it has to be, there's only one way a jury could rule? You'd be right to scratch your head. That's our legal system. But you have, lawyers on both sides. As a matter of course, they would always do it boldly, saying we get summary judgment. All right, that is what happened this week on Tuesday and Wednesday in a Delaware court where the trial is scheduled to take place April 17th. So both sides had extensive arguments before the judge, because this isn't just the law, it's the facts. They want to say, look, judge, we have to win. Look at what all these people said in deposition. Look, judge, we have to win. Look at what all the interrogatories say, etc. So Judge Davis, it's pretty clear, gave Fox the harder time. Fox's basic approach, because they dealt themselves a very bad hand, where they have all kinds of evidence that the falsities, and of course they are falsities, these publications of the big lie, were knowing, and people knew all the way up to the top. That's the kind of stuff that Dominion emphasized when it was their turn. Fox's basic approach is to say, look, all we were doing was presenting the views of others, third parties like Rudy Giuliani or Sidney Powell or other Trump representatives. And that's not us. Nobody could take that as being our views. The judge wasn't buying it, really, and they pointed to specific things. And I think it was pretty clear that Fox was in retreat and that Fox can't really hope for summary judgment here. Now comes Dominion. They want to say we win on the facts because it's totally clear things are false, and it's totally clear from all these statements that Fox knew they were false or was reckless about it, and that's the constitutional standard, and therefore we must win. The judge was similarly, if not skeptical, he seemed unpersuaded on that most important second point. Did they know? Because there's some evidence you could take as at least suggesting, letting a jury decide. Did they know for certain, including the people who were broadcasting it? At least, he doesn't want to take that away from the jury. That would to grant summary judgment for Dominion in a case of this enormity with so much at stake. I think a judge would be loath to do. However, there's some suggestion that he would be willing to rule an aspect of the case is subject to summary judgment in favor of Dominion, and that would be the falsity of some of the statements. So the statements that they repeatedly published that, Trump won or was all corrupt, or Dominion had huge tampering with the ballots, et cetera. At one point, he really presses Fox and said, look, is there any evidence at all that Dominion, as people said on Fox, had actually, that the Dominion software had misoperated or somehow had counted wrong votes? And the Fox lawyers sort of, huffed and puffed and went on, did a little jig, and then finally pressed to the wall. They said, no, there's no evidence, and we're not going to be claiming it. So they admit false things were said. But they're going to want to say two things at trial, but it'll be up to a jury to decide. One, it wasn't really us talking; we were just presenting. And two, we didn't know that it was false according to the standard of the law. Both are going to be rough roads for them to travel. Dominion, however, may be able to get a ruling from the judge that at least we know that the things were false. Certain statements, in a defamation case, by the way, you go statement by statement, that certain of them are false, so that's off the jury's plate. And you just go to the state of mind that Fox had when the statements were broadcast over Fox. That's maybe not even such a bad thing for Fox, because if they have to stand up at trial and make a far-fetched claim, in fact, they probably won't now. If they have to stand up at trial, and by the way, they have a tremendous, one of the top trial lawyers in the country that they've hired, so they know they're in a really, really existential fight. But if they would have to stand up and say, the sky is green and up is down, by saying these were true statements, they'd lose all credibility with the jury. So they probably won't do that anyway. All right. So it really looks as if this trial will go ahead on April 17th is when it's scheduled. It's going to be one of the most important defamation trials in American history. The summary judgment motions, Davis says he will rule on around the time or before the next pretrial conference, which is scheduled for April 10th. That's when you do all the sort of logistics. How are we going to pick the jury? Who's sitting where? What are we going to do with the computers in the courtroom, and the like? So that's like really when you're zeroing in on the final days. But that's when he's going to give his ruling and summary judgment, which I'm sure will be written out. And that's the kind of thing that a court of appeals might really scrutinize closely, because it's a legal question. Technically, it's a legal question whether no jury could possibly decide one way or another. So he'll write it out. He'll write it out carefully. We'll get it a little before the 10th, and then we'll be looking almost certainly at trial come April 17th. So for sure, there'll be a lot to follow. We'll be there to follow it, to give you the highlights, and along with my analysis. Till then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.